Good afternoon, ladies and gentlemen. Could I request our partner to also come upstairs, Patrick Handermark, also come to the podium. Whilst we wait for them, let me also be protocol compliant. Excellencies, Chief Justices, Justices, Ministers and Deputy Ministers of Justices, legal aid providers, ladies and gentlemen, it is always an honor to stand in front of such an august crowd of learned people. And the past 3 days has proven very invaluable to me. I'm happy to say you all heeded the call that let's talk frankly and let's come up with practical, tangible, and objective strategies to implement the United Nations principles and guidelines on access to legal aid in criminal justice systems. I'm sure I'm speaking for everyone that this has been one of those conferences where all the participants have remained engaged with the issues at hand, whether in the plenary or in the parallel sections or even in the breakout sessions. I visited a number of them and I was hugely impressed by the level of participation. I also want to echo the sentiments that everyone has mentioned, that we have all learned. We've learned from each other. We've realized that there's best practice elsewhere. So before I go further, I just want all of you to join me in giving you all a big round of applause. I also want to take this opportunity to thank the moderators of all the sessions, plenary, breakaway, parallel, as well as the speakers in each of those sessions. You all came with your particular expertise to teach us. I sat in some of the breakaway sessions. I sat in the paralegal breakaway session this morning and heard of the innovative ways being adopted in Nigeria about how to raise awareness of the people about their legal rights and access to legal aid. So folks, I think the moderators and the speakers in particular, the contributors, also deserve a huge round of applause. I also want to welcome on the stage here Zaza Namoradze. He led the subgroup of the steering committee that was looking at the outcomes document. You remember when we started, we said we would like to come out of this conference with a document that tells us, in brief, not to repeat what the principles and guidelines say, but to say how do we go forward in implementing those principles and guidelines. And I was happy to learn that there was a very good response from participants to join the working group that looked at this document. It was a long document. It has been shortened. I'm told people left the dinner last night to work. Some people left around 2 a.m. But that shows commitment. So I think the working group members, Zaza, the leadership, and the people sitting on this stage also deserve a huge round of applause. This session is meant to look at the draft that was circulated to you. about what do we do from here. Sitting and taking my own notes, I recognized 4 very broad themes that come out of the discussions here. The first one, and you had the powerful presentation from Argentina about international cooperation. From a support level, either financially, on information, etc. I think that's one of the big themes that has come out to say, how do we implement these principles and guidelines? We also had a lot about the role of non-lawyers as primary legal aid service providers. I'm talking about paralegals. I'm talking about the roles of legal NGOs. I'm talking about the roles played by universities. There was talk about the revival of student practice rules. But that's one of the other main themes that came out of the discussions here. The third one was a very delicate one, but it is the elephant in the room, is how do we coax governments to support policy reforms, legislative enactments to establish, support and fund legal aid institutions. It's a very big problem. It's always been a problem. But I'm happy as I sit here, having been an activist on this platform about legal aid for vulnerable people, that the situation is improving, but we're not there yet. So that's the third main theme that I had been spoken about here. You also heard about the role of UN agencies, who I'm happy were part of the organizing of this conference, about how, and other international agencies of course, about how they can support either financially or technically the efforts that we see in country programs via NGOs or via groupings in each country and regionally to make sure that legal aid access, quality legal aid access becomes a reality. I'm sure I may have left out some, but to me, those are the 4 main themes that I had been spoken about here. So without wasting any time, I've invited the main participants from the co-host. You've seen them. It's Zaza Namoradze, who had the subgroup, Jennifer Smith from the ILF, Ms. Miri Sharon from UNOGC, and Professor Yusuf Vara from Legal Aid South Africa. They are going to be helping me. Aparna Baznyat is trying to avoid coming here. She represents the UNDP. And if I can tell you the story about Aparna, when we started planning this conference, because we spoke to each other without having met each other, she would speak to us from New York, and I had the unenviable task to chair the steering committee. And she gave me a lot of hassles in the meetings. She proved very troublesome, like Jennifer was in Vienna in October 2011. So I said to Aparna, well, I hope you come to South Africa, I'll sort you out. But when she came in, I met her for the first time, I said, oh my God, there's nothing to sort out here. Aparna, welcome to the stage. Thank you very much. Let me, before we interrogate the document fully, I want to invite Zaza Namoradze to come up. Zaza, I would request that you just deal with the main themes of what the document says about. Don't go through the document word by word, so that we can then tackle the document and decide whether it contains what we want it to contain. Thank you very much, President.
Thank you, Justice Mlambo. It's a real privilege to be here, to be presenting the draft to you, all of you. That is a result of the work of many of you. And at the end of this session, it will be the work of all of you, as I hope all of you will be wholeheartedly endorsing the document. which we have presented for your discussions and questions and comments at this session. Justice Mlambo really well explained and well captured actually the main themes of the discussion. Indeed, these are the themes that are reflected in the document. So we in the working group decided to focus on several key themes on which we wanted to really send messages to those institutions at various levels, national, international, non-state actors, which are in a position to put them in practice. And therefore, another kind of an objective we set in the process of drafting this document was to be very practical, very precise, very succinct, and very clear of what it is that we are asking as a group of people who are committed to legal aid reforms globally. There is as you have seen, there is a preamble, introductory part of the document, which then turns into 3 sections. The section starting with the states, then moving to the section of legal aid service providers, which includes broad range of legal aid service providers from governmental service providers to non-governmental service providers, and many of the aspects that Justice Mlambo mentioned, university law clinics, community-based paralegals, civil society organizations focused on specific vulnerable groups, and so on and so forth. And then we go to the 3rd section, somewhat longer section, of asks, if I may put it this way, the address to the international community. And in that section, we have several different elements, the one of which is addressed to the UN Doha Congress, really recognizing this incredible opportunity of major events that happens every 5 years. The event which sets the agenda for the Crime Commission's work and UNODC for the coming 5 years, and an agenda of which, for one of the main themes of which next year is going to be implementation, broadly defined. That is exactly the main theme of our event in Johannesburg now, and probably our main theme underlining the entire document that is before you, that proposed draft declaration. We have, during the last 3 days, we also talked a lot about importance of monitoring and data collection. This theme came up many times. And we all recognize that this is a very important element to really understand what it is that happens in practice, what it is that is going to happen in practice, and then how to give meaning to an understanding to the beautiful document that is the UN Principles and Guidelines on Legal Aid, and how do we know how much it is working or does not in practice, and what are the things that needs to happen to help the government, help the civil society, help the legal aid actors to implement them. For that reason, so we put forward also the proposal that a mechanism for monitoring be established that can continuously, which is already included in the UN Principles and Guidelines. There was the requirement for a report of the Secretary General on the progress of implementation. So we are proposing by this document to have this to happen on a continuous basis, and whichever tool then obviously the UN agencies will find most useful to apply here, whether it's questionnaires or requesting the information to be submitted by the member states, but it's kind of they need to, probably they would be in the best position to determine that, but we thought that this would be really important to propose. And then we talked a lot here as well in several 2 or 3 paragraphs about the importance of cooperation, international cooperation, a theme which was so well also presented and discussed at the previous session. So this is more or less what really we have presented to all of you. As I mentioned, initially we thought that there would be a small annex to this document to capture the key findings and recommendations from the breakout groups and mainly thematic discussions at parallel and plenary sessions. But then at midnight last night, we actually realized that it's probably not feasible in this short period of time, one, and the second, it did not really belong to this document. This document is really about something else. They're having a short statement of asks addressed to very specific institutions, while the document, which obviously will be produced, and Jennifer talked about that, the comprehensive report from the conference with executive summary, probably summarizing all the key findings and recommendations, which will be helpful to all of us and many other people who were not able to join but probably are interested in this topic. So here we are with this document. You all received it around 9:30 a.m. this morning. I hope you've had a chance to read 2 pages, and this is the time to make any observations, comments, suggestions, questions that would help take us forward to finalizing the document, which hopefully we can endorse in about 45 minutes from now. Thank you, Justice Mlambo, and I will leave to your leadership now to take us through this commentary section.
Thank you very much, Zaza. There are 2 issues that I thought let me deal with before we deal with the document. The first one is that today is a very important day to Madam Justice Yo of Liberia. It is her birthday today, so let us join me in congratulating her on attaining the age of 21. The other issue is that today is a milestone day for this country. It is the day on which so many years ago, 59 years ago if I'm not mistaken, a document called the Freedom Charter was adopted. Those of you who know and have followed the history of this country will know that that document has had a critical influence in the development of the political life of this country. We sit here today, we have a constitution, we live the lives we live, we have a legal aid system like we are able to host conferences like this because the origins started 59 years ago. So it's a very milestone day for us here in South Africa because that's when we adopted the Freedom Charter. Now, as Zaza mentioned, I would like us to look at the document. I will request for comment. What you will see is I requested the subgroup not to repeat the principles and guidelines in this document because there's no need to do that. We are here to come up with strategies and action plans that implement the principles or that suggest implementation ways. So that's why you don't see a repetition of the principles and guidelines in this document. And it is a document that is based on what the subgroup had coming out here. It reflects what people were saying they would like to see. So that's why you say it says we. It's a collective document, so I'm saying this to encourage us all not to adopt a dogmatic, individualistic approach to this document. It's a collective document that reflects the collective discussions. So I would like you to look at that document in that spirit. It's a document that tells the world that we came, we met, we discussed, and this is what are the things we want to see happening for the principles and guidelines to become reality. So to kickstart the process, I will just request comments first regarding the preamble. If there's any comment or if there's any additions or someone has a particular issue with a particular provision. Justice, you?
Thank you. I've just read over the preamble, and I don't see where, or I would suggest that a paragraph be placed there to indicate the benefit of legal aid to government. For example, if people are accorded these rights under the Constitution of any country, their dignity, to know that their dignity as a human being, is protected, I think it go a long way in benefiting the country and in some way, advances peace in that country. So I think we should include a paragraph there about the benefit to any country to advance legal aid.
Thank you very much for that suggestion. I think we tried. There was an effort to try and capture the benefits. Although I don't know what you have in mind. Probably you have some cost benefits to states which are not mentioned particularly. But if you look on the third last paragraph, which states that without access to effective legal representations, what are the consequences, as well as, I think that paragraph going on to the last one in the preamble, is trying to capture, in a sense, what the benefits of access to effective legal aid services is. That would be my response, but I'm not cutting you out, but I just want to see if there's any views on that comment or on my response to that comment. I don't see any hands. Oh, wait, sorry. Yes.
I'm not sure if this is groupthink or not, because I'm here from Liberia as well. I think that your comment is well taken, and at the same time, I understand Justice Yo's comment.
Yeah.
One of the things that we suffer from in Liberia is that people don't have access to justice, and that ends up with people taking justice into their own hands. So it is, in addition to that, there is the effect when people are not afforded access to justice. It does lead to instability within and insecurity within the country. That's my comment. And just one other on that. We talk about, just in that same sentence that you referred to, millions of poor and marginalized people. I would also add, because they're not the same to me, vulnerable groups. Marginalized is once they reach the system, but they're vulnerable. Thank you.
Thank you very much for that comment. Is there any suggested wording, or do you want to improve on one of the paragraphs that are there to add what Justice Yours suggested?
I will do that, and if we can come back.
Okay, we'll go on to other comments, but I think I'm taking your comments, and I hope the House agrees. Thank you. There's a hand there.
I think my only comment was perhaps in the first paragraph to make the point that these were unanimously adopted at the General Assembly, perhaps just to add weight in the first paragraph.
Okay, thank you very much. Okay. Yeah, we've put the document on the screen for us to note the changes. So you say in the first paragraph, we should not lose sight of the fact that these were unanimously adopted, right? Where would you suggest we put that?
In the final, penultimate line, there's adopted, if you just insert unanimously before that.
Oh, okay, thank you very much. I've seen that. Yeah, yeah. Can you just insert that word there, please, Rupert? Unanimously. Right.
Yes, good.
Thank you very much. We'll come back to the suggested additions to about the benefits of providing access to legal aid. Any other comments on the preamble? Yes.
Merci beaucoup. Voilà. Monsieur le modérateur, je rappelais tout à l'heure que malgré qu'il y a eu un panel entier sur l'instance juridique et judiciaire dans les matières civiles, parce que les principes portent sur la justice criminelle, une place n'est pas faite sur l'importance de l'instance juridique et judiciaire dans les matières civiles et administratives. C'est revenu, et évidemment que partout il est parlé de criminels, parce que sinon le problème qu'on aura, c'est que les gouvernements qui n'ont pas encore adopté des lois, ils vont penser que cette question s'arrête seulement à l'aspect de l'instance en matière criminelle. Donc, c'est un texte fondateur que nous adoptons qui va encourager les gouvernements. Il faut dire que nous reconnaissons ici l'importance de l'instance juridique et judiciaire dans les autres matières, autres que criminelles, civiles et administratives. Ça me paraît important pour compléter le préambule. Je vous remercie.
Thank you very much. I can tell you, thanks for that. I think I noted it when you first made the intervention, that it was a compromise position from a steering committee point of view to include a session, simply not to lose sight of the fact that there's need for civil legal aid. But our view, and I think Zaza will speak to it. Zaza, you want to talk about it?
Yes. Actually, there is a sentence that is missing in this version. About half an hour ago, I emailed it to Speedy Rice. Actually, I would like to take this opportunity to really thank Speedy for really producing what is here by listening and getting all the comments and turning it into, after many hours of work. So there is a sentence which is added to the fourth paragraph, which reads in the following way. In this regard, these groups also have many unmet legal needs in civil matters, which need to be addressed. So that's the sentence that's how the fourth paragraph ends. I would like to say that, may I? There was because we were kind of making efforts to make the document on 2 pages. That was kind of the target we kind of set. The initial one was much longer, and in the initial document we have a section which may be responding to the comment on the benefits more, which we kept it as Justice Mlambo described, but there was a paragraph which we took out, and it read the following way. Moreover, the cost of not providing free legal assistance supersedes the cost of its provision and has significant financial ramifications for individual pretrial detainees, their households and communities, and for states processing large number of pretrial detainees. Reducing the excessive and arbitrary pretrial and use of pretrial detention, which legal and early assistance schemes can be designed to do, also improves the administration of criminal justice, increases public trust in justice, and can boost socioeconomic development at the family and community level, especially in developing countries where the difference between a stable existence and their survival is often tenuous. So this was the section we had. We dropped it because of the kind of constraints of the space. If you believe that it should be put back, we will put it back, and then would it respond to your point? Yeah. Okay, it's very easy. So we have the text, it's written, so we can put it back. If people...
Thank you very much, Zaza. But let's start first with that sentence that responds to the civil legal aid inclusion. Do you want to read it back slowly so that it can be captured, we can see it?
Okay. Could we go to the fourth paragraph in the preamble? Without access to Yeah. Yes. And so it continues. In this regard, yes, so in this regard, yes, please, in this regard, these groups also have many unmet legal needs in civil matters. These groups have many unmet legal needs. Unmet legal needs in civil matters, which need to be addressed.
Would we be happy with that inclusion?
I suggest that at paragraph 5, the first line, we said we reaffirm that the legal aid is an essential element of a fair, human, and efficient justice system. Or justice, you don't need the adjective criminal.
Thank you for that, but I think this is a quotation that comes from the principles, so you can't change it. And I would like to think that that sentence that we've added caters for your concern about capturing that civil legal aid needs are also necessary. Yes. Okay. I see a number of hands now. Okay. 1, 2, 3.
I know this is covered in the general terminology and in the principles and guidelines, but I'm just wondering whether we should specifically make mention of children as a vulnerable group and their specific needs and impact that it might have on their lives.
My gut reaction to that is, I think that suggestion of marginalized and I think what was it, vulnerable captures those groups. That would be my gut reaction. I don't think that's acceptable to you, because children are recognized as a vulnerable group universally. Professor, are you happy? Thank you.
Yes. My observation is on paragraph 4 also. I think it lacks of any reference to victims, and the United Nations principles are also referred to victims. Probably I misunderstood it. So probably I will add as other problems, risk of arbitrary, extended, illegal detentions, etc. I will put revictimization or something like that, just because I think victims are being out of these problems of lack of representation.
Right. Where would you include victims? It's true, the principles and guidelines talk about victims extensively. Where would you want that to be put?
Well, probably in paragraph 4, we could say without access to effective legal representation, millions of poor and marginalized persons face risk of arbitrary, extended, or illegal, blah, blah, blah. And then we could put, after social stigma, detrimental impacts, libel and other abuses, and re-victimization of victims would be there or any other place. Because if not, the victims are excluded, and I haven't seen them in other part of the document, either the preamble or the last part.
Okay. I saw a hand shoot up. I'll come back to you, sir. Let me hear the lady behind you. Next to you, sorry.
Je reviens sur la question qui a été posée par le ministre de la Justice du Niger. En fait, la demande, c'est de mettre en exergue l'assistance juridique en matière civile dans le titre même de la déclaration.
But I thought we accommodated the civil legal aid. put it in the code.
Sorry, through you, Chair. I think I understood the Minister to make two suggestions. The first was in relation to extending it to civil legal aid. That is a sentence that has been added to the end of paragraph 4, right? Yeah. And then the second suggestion related to the removal of criminal from that quotation in paragraph 5. And I think our problem is that that's a quote from the UN principles, so we can't do that without changing. There is no quotation. Chair, while I have the floor, can I make a suggestion? Earlier we had Justice Yo raise the issue of development. And I'm wondering whether at the end of paragraph 5 we could craft a sentence or formulation that would accommodate that need. Now paragraph 5 says that legal aid is an essential element of a fair domain. That's the quotation we talked about. And it talks that it's the foundation and should be guaranteed by the state. If we added a sentence here to the effect that further, the denial of this right has detrimental effects on the development of society, so it's a general statement, at that point, would that satisfy the request?
Well, the hand shot up immediately.
I also had a suggestion that we worked on. And if I may read it at this point.
Yes, please.
We acknowledge that in post-conflict and developing countries, people who are provided with free legal aid and representation are less apt to resort to non-lawful self-help alternatives and thereby avoiding situations which erode security and which could lead to conflict.
I don't see any response, so I think we could have it typed. Can you type it? Let's see. Can you just read it out slowly, please?
We acknowledge that in post-conflict and developing countries, people who are provided with free legal aid and representation are less apt to resort to non-lawful self-help alternatives and thereby avoiding situations which erode security and which could lead to conflict. So I was proposing this would go right after the without access to effective legal representation.
Yes, I think it's just been added. Can you just look at the text that's there, if it reflects what you suggested? After the word guidelines, that's where it starts. Are you happy with that insertion?
Yes.
Okay. Thank you very much. There was another hand here. Yes, sir.
I propose in para 5, which starts with, we reaffirm that legal aid is an essential element of a fair, humane, and efficient criminal justice system that is based on the rule of law, and that it is a foundation for the enjoyment of other rights, including the right to fair trial thereafter, and should be guaranteed by the state. Here I would like to add or suggest as fundamental right. Should be guaranteed by the state as fundamental right.
Doesn't the principles and guidelines expand on?
Actually, why I'm saying so,
Yes.
I am from Pakistan.
Yeah.
In our constitution, there is a chapter of fundamental right. And Article 10A say that every citizen should be given a fair trial. But as far as the this legal aid is concerned, if this is included as a part of fundamental right, then it will have more sanctity to it. So this is my suggestion.
You see, when we were negotiating the principles and guidelines in November, or in October 2011, this issue cropped up, whether it's a fundamental right or it's an element of a fundamental and humane process. Because you can look at any instrument, you won't find it reflected as you are proposing. Yes.
Yes, thank you. My name is Maha from the United States. I just wanted to further elaborate on the Judge President's point. In Vienna, when we were negotiating the document and the resolution, this was a very important sticking point that many countries insisted on not calling it a fundamental human right. In my country, of course, there is a right to counsel, so it's not in conflicts with my laws, but that under international law, the right to counsel is a component of the fundamental right to a fair trial. So I think we need to leave it as that because that's been heavily litigated before. But I also would like to just caution that whatever we put in this document, to consider that the UN principles and guidelines are quite it's a very comprehensive resource. And if we start to pull out items to put in a preamble, it might confuse people as to why we're considering some things more important than the other when we have limited time. And I'm a little nervous because we supposedly have to end in 20 minutes. I think many of us have flights to catch. And so that's just one thing I would caution that we consider. If the UN principles and guidelines address the concerns that you may have, then let's just make sure perhaps that the preamble appropriately references the document. The second point I just wanted to make was this new addition that was added on post-conflict and developing countries, etc. I believe really my colleague's request was to have it added to the end of the paragraph above. So that in the paragraph above where it's talking about legal representation for poor, vulnerable, marginalized, this discussion of individuals in post-conflict countries flows from that. That's just a technical fix I think was a request. But anyway.
Yes. Thank you very much. So we just put it above. I don't think that does any harm. In fact, it actually rhymes well. But I just want to go back to the fundamental rights. I chaired that session. It was a sticky session, and it threatened the whole process. That's why it was left as the principles and guidelines say it is, and I would recommend that we leave it as it's saying in the document. Please.
Please. Et je voulais vraiment savoir si la déclaration doit être figée dans les principes et orientations des Nations Unies. Nous avons fait une conférence qui déborde des principes, qui s'est inspirée de l'exemple sud-africain, de Moldavie, des Philippines, et nous avons relevé des préoccupations fondamentales et larges en matière d'astreinte juridique et judiciaire. Je crois que les principes, ce sont un minimum. Les principes, ce n'est pas un maximum. Ici, je pense que notre conférence a largement débordé les principes. Et c'est important que notre déclaration reflète nos discussions et nos préoccupations. Et c'est pour ça, même si le thème de la conférence est sur la justice criminelle, je pense que, en tout cas, nos débats dépassent largement la justice criminelle. Et c'est pour cela que je pense, au moins dans le titre, on doit pouvoir dire que c'est l'aide juridictionnelle dans le système judiciaire. Et je pense que c'est important pour l'avenir de l'aide juridictionnelle. Il ne faut pas qu'on soit conservateur. Sinon on ne peut pas faire avancer les choses au-delà des principes. Merci.
Thank you, Minister. Thank you for that intervention. But I think we were clear when we conceived this conference that we're coming to look at the implementation of the principles and guidelines. And I know that the principles and guidelines do make mention of the judiciary role on the provision of legal aid, access and provision and services. So I don't think we can change the title. And if I understand you well, your concern was civil legal aid. And I want to believe that we've catered for that. in the sentence that will be included. And can I encourage the House to move on now? I think I don't want to be pushed into a situation where, as Judge President of this province, I ground all flights before we finish. I don't want to be moved to that position. You see that?
Good afternoon, Justice Dunstan. Yeah, one short comment. In a criminal action, the civil action is impliedly instituted, the civil aspect. So there's no problem about civil legal aid. In every criminal action or legal aid in criminal action, the civil action is also there. It is impliedly instituted. So I move that the preamble, as amended by the body, be approved in toto and unanimously by the body, and move to the next portion.
Okay. I think just coming back to the Minister's concerns, we are all clear. We came here to look at the implementation of the principles and guidelines. And the principle and guidelines is an expansive and exhaustive document. It mentions all the aspects that you've mentioned. And I want to believe that your particular concern about civil legal aid has been catered for with the amendment of the preamble. And I would request that we move on. Please. Thank you. Are you supporting Persida? Yeah. Yeah, let's go on now. I don't see any other hands about the preamble, so I take it we're happy. We're moving on to the action plans. That's where you're going? Thank you. Oh, sorry. You're still on the preamble?
No.
Oh, okay, yeah. I think you're the second hand. Go ahead, sir. Go ahead.
Thank you. Second point, we call upon all legal aid service providers and so on. Furthermore, we encourage legal aid systems to also utilize paralegal and university legal aid clinics, and so I suggest to write, we encourage legal aid system to also utilize paralegal and university legal aid clinics. I mean, it's absolutely necessary that the legal aid system have the assistance of an attorney, a technical assistance. So I think it would be more clear if we say that the legal aid systems utilize attorneys and also paralegals and university legals and aid clinics and so on. And I have another point.
Well, let me just understand. Furthermore, we encourage legal aid systems to utilize attorneys and also, that's all, isn't it?
We encourage legal aid systems
to
also
utilize attorneys and also. I think that's what you said.
Utilize attorneys. Perfect. Better than my suggestion. Another point.
Wait. Are we happy with that? Is there opposition to this insertion? Okay.
We wouldn't have attorneys in all the jurisdictions. For India, we don't have attorneys, so the word attorneys might not really be meaningful for all.
Attorneys are lawyers.
Yes, that's there, but then you can use the term lawyers.
Can we put the word where applicable?
Or just put lawyers.
All lawyers.
Just put lawyers.
Lawyers, yeah. Okay. Okay. That's fine, lawyers. That solves that, okay? So we accept that, okay? Lawyers. Yeah. Any opposition to that? No opposition, okay? There was another hand here for another, before I come to you, I've recognized.
I have another point, sir.
Oh, sorry. Okay.
The other point is letter A. Letter A is supporting the application of existing standards, including through the provision of technical support to develop, I would say, develop independent systems of legal aid. Because the independence of the legal aid system is really important. It's stated in the principles and guidelines, and I think must be reflected in this document.
Well, the principles mentioned that. Zaza?
Just on in this paragraph, because this document does not reflect kind of the one suggestion which was communicated to me, and then I proposed was to insert the word international after the word existing international standards, because the person who raised this mentioned that existing standards, if it's national standards, maybe they are low standards. So we should just really probably this refers to international standards. So
Existing
international standards, so it makes it clearer.
Right. And the one about lawyers, we've captured it?
Yeah, it's captured there.
Okay, thank you.
It's captured.
Yeah. And the independence? Look, the principles mentioned it, so I would imagine there should be no debate about it. Okay, thank you very much. I think there was a hand here.
Are we on recommendations?
Yeah.
Let me first say that I have admiration for the working group, and so please understand these comments as productive as you possibly can. In terms of how to do this, my approach would be that I'm not expecting any responses, but I have full trust in the working group to take recommendations and comments on board, and just, we can't do drafting here, I think, in the little time we've left. But here's my main comment. What I'm concerned about is the imbalance between what we request from states and what we request from the international community. And specifically, the only call we are formulating to states is to proclaim political will. And as an organization who tries to convince states to actually implement international standards, my worry is that the message is you proclaim commitment, and otherwise lean back, and the international community is going to do the rest. So I think I would feel more comfortable if this was stronger about the obligation of states to actually implement that. This being said, some of the points mentioned under international community, for me, are also calls upon states. They may be activities at international fora, but ultimately it is states who need to support them and adopt them. And that refers to B, C, and D under the section of calls upon the international community. And one that I would add is for them to incorporate the rule of law in the new MDGs. As we all know, the funds are going to depend on what the MDGs expressed as priorities, and so if this is not incorporated, I think it's not very likely that our deliberations about funding of legal aid systems is very likely to happen. Thank you.
Thank you very much. Zaza, no respond to that?
On the states, actually we had a long section on the states until last night. As we were shortening the document, we decided to significantly shorten the states part here, because actually everything that we were saying in the state section is already in the UN principles and guidelines, because it's addressed to the states. So it asks the states to introduce early access systems. It asks the states to make sure that there's a letter of rights. It asks the states to establish legal aid management institutions. So we just kind of were repeating it in a way. So we decided that we wanted to say something, or emphasize overall point, but not to go into detail what UN principles and guidelines was already saying. So it's also in line with Justice Mlambo was saying, that to avoid what is already very well said by the UN principles and guidelines. And on post-2015, so we have a reference to the post-2015 in the preamble. So there is it is paragraph 3. And then shared in discussions on the post-2015 Sustainable Development Agenda on eradication of, yes, so it's the end of the post-2015. Probably, but you meant probably to have a stronger...
I have seen this, but it doesn't call on states explicitly to include the rule of law.
Yes.
So it's a very general
I see.
reference.
Yeah, I see. So you're suggesting to have it in a section, which one? Where, like,
for me, it's a call upon states.
States to agree to include access to justice and rule of law as part of the post-2015 development agenda.
Judge?
I mean,
why don't we You know, because, you know, this rule of law, okay, Apana.
I think just to follow up on the point that was just made, you know, if we have the last section, which is the A, B, C, D, E, F, as action points, and so then there's equal sort of attention to each of the three areas in you know, section 1, 2, and 3, and then these are action points in general that apply to states or the international community. Maybe that would help in terms of structuring the document, and then we can also include a point on there on calling on states, as you're saying, to include.
Judge, I think the section is perfectly strong enough because on the next line it says fully implementing the provisions. How more stronger can you want? So while it says political will, it then says by fully implementing the provisions.
I think that's, I'm told that's the working group were happy that they felt that language strongly captured.
Sorry to be nagging about this, but I don't understand the meaning of to proclaim political will by fully implementing the provisions. That doesn't make sense. If you read
Can you propose something then to make it say something?
I would call upon them to fully implement the provisions.
Chair, can I maybe suggest something? Yeah, the language could be improved. Would it help, we said, to demonstrate political will by fully implementing these UN principles and guidelines? In a sense, as Prof. Tusen says, the entire sentence has to be read as a whole. So, you know, from demonstrate political will by fully implementing the political will.
I think that takes care of your concern that it says nothing. They will be demonstrating that political will if they implement, isn't it?
I don't think it's very strong, but it doesn't make sense as a sentence. How do you proclaim political will by implementing?
We change in proclaim into demonstrate.
The main point, I mean, to proclaim political will is maybe a statement, and that's terrific if they do. But then they have to actually
proclaim
initiate.
And demonstrate.
They have to
No, I
initiate.
think what she's saying is that what this actually says is it's saying that states should demonstrate the will to do it, but it doesn't say they have to do it.
Yeah, I think it's just a problem. I understand the grammar here.
So what's the suggested change then, please?
Yeah, I think what you're saying is to just delete the first part of that sentence, right?
I don't mind if they proclaim their political will, but separately and to initiate prompt implementation or something. And that indicates it's a separate thing to proclaim that you're willing and to actually do it.
Yeah, can we then have something concrete to put in the document, please?
We call upon states to proclaim political will and commitment, and then the text remains the same, and to promptly and fully implement the provisions of the UN principles and guidelines.
And fully.
Are we against that suggestion? You happy with that? You want to come with something else? Okay. Have we captured it? Have we amended it properly? Okay. Right. There were two other hands that side before I come to you.
I didn't suggest to delete all that info, I just didn't read it out. Basically...
So can you just read it slowly how you want to see it? Because I don't want us to waste time on this.
It's only a little change from what there was initially, so I don't know whether you can go back and I try to explain more clearly what I...
It would be easier if we could...
To proclaim political will and commitment to achieve the aspirations and objectives as set out in this declaration, and to fully and promptly implement the provisions of the UN principles and guidelines, etc., etc., as it was before.
Objectives.
So Jody, we are missing proclaim at the beginning still. So just to take the...
To proclaim, yeah. No, that stays. That
stays.
That's say to proclaim and demonstrate.
To start with, that we call upon all states to proclaim the political will.
And demonstrate.
And demonstrate the political will, yes.
And, yeah, and then it's not objections down there, it's objectives. Objectives, take out the S and take out the second N. Right, thank you very much.
And then grammatically it has to be fully implemented. Not implementing.
Fully implement, okay.
And fully implement.
No, but if it's by fully implementing, it's correct. Okay. There was a hand there, yes?
Yes, thank you. So I just wanted to make a comment on section 2. One is just a point of clarity for the working group.
Yeah.
I'm assuming that the intention of this, where it reads, furthermore, we encourage legal aid systems to utilize paralegals and university legal aid clinics. I'm assuming that the intention there was to try and look at how we can meet the demand for legal aid, utilizing everything at our disposal, in addition to state resources, and Zaza's nodding. So I'm just wondering why you've got that finite list there which says paralegals and university legal aid clinics. I think that there are a number of mechanisms one could make use of. We've discussed pro bono quite extensively here. We can talk about village mediation. We can use and a range of others. I'm not going to go into that now, but I think if the intention is to say that we shouldn't rely solely on the state, then that sentence should reflect that more strongly and not limit itself to paralegals and university legal aid clinics. And then I just wanted to say, and I'm speaking largely now in the African context, is that what we've been grappling with since the Lilongwe Declaration is to get recognition for paralegals and codifying the role of paralegals in legal aid law. So I think that there would be no harm, as far as I'm concerned, in saying something like recognizing and utilizing, or something a little bit stronger in terms of actually getting a right of appearance for paralegals, or if people object to that, then certainly just defining more clearly in law what their role is. Thanks.
Yeah, I don't think we need to be very detailed, because this is just succinct action plans. Now, in terms of the paralegals and university law clinics, are you saying we should not mention them or add to the list and mention others?
I think it's could we, if we add and other civil society organizations, pro bono services,
That'd be fine.
Zaza, I wouldn't want to start drafting now, but what I'm suggesting to you here is that the way that you've written this and the way that you've crafted this sentence sounds like you're only suggesting those two. And what I'm saying is that there are many ways you could decide on a list as the working group. I don't want to start drafting here. Or you could list, and I could certainly say, I would add, public defenders, pro bono services, paralegals, etc. So it could be 4, but I wouldn't have a finite list, no.
Yeah, no. So I think that this will benefit from adding civil society organizations and pro bono services. I think lawyers are already there. It was added, so it covers public defenders.
I think we should just say and other.
Yeah, or and other, exactly, or civil society organizations and other. So just to widen it, so it's not only paralegals and clinics.
Is it captured? Guys, I don't want us to...
So it would be, it's in the furthermore, legal clinics, civil society organizations and others, and develop partnerships with, yeah. After clinics you can put, paralegals, if you come before paralegals, so please delete "and" there.
Just before university.
No, where is the lawyers, and also paralegals, comma, civil society organizations, comma, university law clinics, so please delete "and." And after clinics, other, and other.
And pro bono.
And pro bono.
Pro bono services, okay.
Pro bono services. And develop, okay, good.
Okay.
I disagree to include the pro bono service. I think it's a beautiful initiative, particular initiative, but we are exhorting the state to provide pro bono service. It's unlogical, I think. It's a private initiative, a beautiful, but don't depend on the state.
Yeah, but the sentence, it says furthermore, we encourage legal aid systems. Yes, it doesn't refer to the state there. I understand your point, but it doesn't refer to the state.
We have a history of development of the legal aid, and we are dealing with the duty of the state to provide the legal aid. The moral duty of lawyers or what else to provide legal assistance, that's okay, we have it, and we're not working on it to encourage private persons to provide legal aid like pro bono. We are talking to the state, so I think to include the pro bono is, yes,
Pro bono.
yes,
Okay.
take it off.
But we can have and other to stay, isn't it?
I'm okay with and others, but the expression pro bono, I think it's pretty bad.
It's not on that, so can I move on?
No. I think there was another hand here. I'll come back to you.
Thank you, Zaza, for putting civil society. That was one of the inspirations. We are calling this only for regional civil society. There should be recognition of also the civil society efforts. And in terms of this effort, I think we all are talking about collaborative efforts. I think we should also recognize, particularly on ensuring the international standard, I think we should also recognize and look at best practices, because some of the civil society and bar associations are already providing in some of the countries, and that we should also recognize it. And again, also some of the civil society initiatives of legal aid also should be considered as part of the national efforts rather than kind of isolated efforts.
Which paragraph are you talking about?
A, supporting the application of existing standards.
And best practices.
Yeah, and best practices. Because we are talking about here like
okay, that's fine, but
international standards.
If we add and best practices.
Local practices, yeah.
Okay.
Okay, Jody, did you get it? So in the section, yeah, and best practices. Okay, thank you.
Thank you. You know, I just wanted to go to the last paragraph, F. I think my colleague on the other side of the room made the good point about some of these recommendations also implicate states. And I'm going to ask Miri for her help on this, because the last one is asking UNODC to do work, and we know that states have to fund that work. So I'd like to just make a little bit of a qualification to have it be a little softer in the same way that it is for paragraph E. So my recommendation would be where it says we ask the UNODC to, and then I would add consider, and then change collect to collecting. And then at the end of the sentence, before the period, that same sentence, giving due consideration to budgetary constraints.
Okay, I think that was the spirit of the guidelines.
That's right, and I'm almost copying what was in the resolution there. So, yeah, giving due consideration to budgetary. Thank you very much.
Have we captured it? Yeah. Sorry, sir, I forgot about you.
Can you hear me?
Yeah.
Great. It's just a technical point, but in 3C, defer to persons suspected, detained, imprisoned, or accused of criminal offense. And that's not quite consistent with the language of the guidelines and principles. The guidelines and principles, in addition, I don't have objection to these terms. It's actually, they're all found in the principles and guidelines, although the term imprisoned is only used once. But in every mention of these terms, in addition to these terms, there's the words arrest and charged with. And these are actually kind of important terms, because these are the terms used in the International Covenant on Civil and Political Rights. And they're used consistently every time there's a list in the guidelines and principles. So I would just ask that the term arrest and charge with are added to this list.
Yeah,
that's
okay. Yeah.
Yeah, that's fine. I think it's in the guidelines.
I can give you the references. You don't have to look at Principle 3, paragraph 20, Principle 3, Guideline 3, the title, Guideline 5, paragraph 45DE, and Guideline 11, paragraph 55A.
Yeah. So we can have the arrested and charged with. Yeah. So in the list of.
Where do you want that added?
We just need to cross-reference to.
Maybe I just read it out and you can correct it.
Yeah.
Where it says person suspected, it said say person detained. Instead of when it's instead of suspected, write persons detained, comma, arrested, comma, suspected of, comma, or charged with a criminal offense. Detained, arrested, suspected of, or charged with a criminal offense. And then you could leave in the imprisoned, I don't think, and leave at the end, or accused of a criminal offense. So end the sentence after the word or imprisoned.
Or imprisoned.
Or imprisoned, and then finish the sentence.
Or imprisoned. Oh, yeah. And then
stop, delete the rest.
Yeah, full stop there, yeah. Thank
Yes. UN editors are smiling now in their offices in New York.
I think there's a full stop there. Okay, suspect that, guys, it's 4:10.
Yeah.
I don't want to phone my clerk to ground the planes. Okay. Patrick?
JP, just the amendment to F. It's fine to say for the UNODC to consider. Why do we have to put the criteria in terms of the due consideration to budgetary constraints? That's something that they can consider. We don't have to add that in. That's tautologist one. There could be other considerations as well. Two, they can also...
Let me answer that. As we said, the UNODC doesn't have funds. It has to ask.
But they can ask for donor funding, JP.
Yeah, but
so why put the criteria there?
There's a reason why we use the word to consider. Okay. What's the next point you wanted to raise? Okay, thank you very much.
So I wonder if you could take on board the suggestion that we include the term vulnerable people in paragraph 2, which we have sort of left already. The last line of 2, which says facilitate access to legal aid services for poor, add vulnerable, poor, comma, vulnerable, and marginalized.
Yeah. It will be consistent, yeah.
Yes.
Okay. Right. Guys, I'm going to take the last 3 hands.
Just a question on F. Wouldn't we want to ask states to collect continuous information and provide it to the UN system? I mean, the onus should be on the states to do it, right? Just a question on that.
That's a very good point.
But on their own, can they do it? How do they do it? I thought the UNODC was a better coordinated mechanism to do it. Mary, we don't want to...
We are the UN's part of UN Secretariat. We take upon tasks that the member states ask us to do. So, but I mean, we can do this by, this paragraph actually has 2 parts. One of them is about data collection, and the other one about the data collection informing the planning of technical assistance. So maybe we can ask member states to collect information and provide that to the UN so that we can do the following. Would that be acceptable?
Can you read out the amendment then? We ask member states.
We ask member states.
I'll raise, we had a long debate on this, and people on the working committee from state parties were very adamantly opposed to putting in data collection specifics on member states, because many of them don't have the ability or the resource to do it. And we had that in there and took it out because the member states objected.
If I may, I was one of those individuals from a member state, and that's true, but I also don't really remember having this fully resolved to be included as well. So there's a tension here between us providing a mandate to UNODC to do work that doesn't have funding to do it, that then falls on the member states, and again, it would be primarily the Crime Commission members, and obviously they can fundraise in other ways. And secondly, you're right that the data collection is difficult, but I think our main point there was not to define which data points were possible. I think there is a possibility to encourage and push states to collect data, but I think the larger conversation that was contentious was all of the individual points that were originally in the document. That was very difficult to do. I just must say, I like Mary's point. I think it works well. It puts the burden on the states, and it also allows for the UN to do its work based on that information.
Okay. So how should that read, Mary? Let's go back to it.
We replace the UNODC with member states, or states, because this is not a UN form, so we can just say state. We ask states to collect, and then at the end of that sentence, before the dot, no, you don't need to, just delete consider. We ask states to collect. And then at the end of that sentence, delete giving due consideration to budgetary constraints, and instead, and provide that information to the UN system. So that my friend from UNDP will keep working with me.
Judge, the state responsibility is in one. I would have thought that this responsibility we are talking about should come there. The state's responsibility to collect data should be included in what we are going on the state to do. That's what I thought. And not in the international place.
I think we addressed this point earlier when we said that after 3 Roman, we will actually delete the words "this includes" and instead have a new title such as action points. And then these are all action points that are directed both to member states and to the international bodies.
Okay, I think that's it. That clears everything.
Yeah.
Minister of Justice, Niger.
Point C, please. C, point C.
Yeah.
Non, c'est l'amendement de mairie, je voudrais qu'on projette ça sur l'écran, parce que c'est modifié sur l'écran. On peut aller au point C sur l'écran. Voilà. Good. Good. Et le point C, 3e ligne. The representation of person arrested. Now, I think we make a first gradation. We must say suspected, arrested, detained before. Il doit avoir une graduation qui a été renversée ici. Donc, suspect vient avant arresté. Vous comprenez ce que je suis en train de dire, Mary? C'est ton amendement.
Oui, mais dans les documents, c'est
Oh, mais vraiment, moi, c'est de pure forme, ça. No problem, we can continue. But we don't need to recognize what we have.
Yes, it's in the original text. Thank you very much. Thanks, Minister. I'm happy you are here, you are participating, because you've been here the 3 days and you've heard the call loud and clear. Okay, folks, going.
There was a suggestion earlier for including a call to states to include rule of law in the post-2015 development agenda. I was wondering whether we could put at a point G.
Can you read it out?
We call on states to include the rule of law within the goals and targets of the post-2015 development agenda. I think that was this.
Did you hear that?
Including a target, we call on states to include the rule of law and access to justice, including legal aid, as part of the post-2015 development agenda.
I need you to go slower.
Can you read it again so they can type it?
Sure. We call on states to include the rule of law and access to justice, comma, including legal aid, comma, as I think including equal access to legal aid. As part of the post-2015 development agenda.
So apparently, just the question, should we reference this as a target, just to make it more clear, or leave it open?
We can.
Because in the development agenda, there are kind of goals, targets, and indicators. So kind of probably this is the target that we are asking for. But yeah,
including equal access to legal aid as a target in the post-2015 development agenda. Yeah.
This will be much stronger rather than just having it as just one thing.
Okay, right. Going. Thank you very much. Thank you. Colleagues, I'm very happy we've reached this level, and I think you need to give yourselves a very big